This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
I'm absolutely delighted to introduce Lord Goldsmith QC. I want to thank Jessica and Vicky from his office for helping us to put this together. As some of you may know, Godfrey Smith was intending to give this talk but had to rush back to Belize, so Lord Goldsmith has stepped in at very short notice, and there's no better person indeed to talk about this case than he. He is former Attorney General of England, Wales and Northern Ireland, currently head of European litigation team of Debevoise and Plimpton, LLP, and he heads the legal team which is representing the Human Dignity Trust, the Commonwealth Lawyers Association and the International Commission of Jurists in this UNIBAM case. And as I say, therefore, there's no one who's better placed to tell us this evening about decriminalising homosexuality in the Caribbean, the Belizean case in Commonwealth and Caribbean perspective. So.
Okay, thank you very much, and good evening to everybody. We'll do a little act in tandem because I'm not good enough at working the computer to change the slides. First of all, as you'll see in a moment, you'll see who the legal representatives are. It would have been great if Godfrey Smith, who's involved in this case with me, had been here, but he has been called back to Belize. There seems to be some sort of election taking place there, and that may be part of the reason for it. So, let's start. Now, what this case is about, fundamentally, this case is about the criminalisation of consensual same-sex conduct. And it's an enormously important case because it's going to test for Belize, but we believe it will have an impact throughout the Caribbean on whether or not it remains legitimate under modern constitutions, under modern concepts of justice, to criminalise same-sex consensual sexual conduct. It's an opportunity, we actually believe, for Belize to lead the way and to set the standard for the Caribbean in righting a serious injustice. And I'll talk about what the case is about, I'll talk about the legal principles, I'll talk a bit about the history that gets us to this point, but it's just worth underlining at this stage what this case is not about. This is not a case about same-sex marriage. It's not a case about adoption by same-sex adoptive parents. It's not a case about any other social or other right in same-sex relationships or relating to same-sex relationships. And I say that because there's been scaremongering, and I call it scaremongering, about this case on the basis that that's what this leads to. I think that's grossly unjust. This case is about righting an injustice. Other issues may be for another time, they may not be for another time. But what this case is about is criminalisation of same-sex sexual conduct. So, what's the starting point? This is the starting point. This is section 53 of the Belize Criminal Code. And it provides, and as you can see, it provides that every person who has carnal intercourse against the order of nature with any person or animal shall be liable to imprisonment for 10 years. Now, the effect of that is that it makes same-sex sexual conduct, puts it on a par with bestiality. There's an issue we'll come back to in relation to that, but it makes it a criminal offence. Not been a criminal offence in the UK for a long time, as we'll say in a moment, in a number of other countries as well. And it's actually worth looking a little bit at what the history of this section is. This is a colonial import. I mean, this predates Belize's independence. It was introduced at a time when there was in fact in Belize no pre-existing culture or tradition of criminalisation or punishment of consensual same-sex relationships. British rulers at the time imposed that, as they did on other colonies. At the time, of course, in England, same-sex homosexual conduct between men never was between women, but between men was unlawful. And again, just continuing the history for a moment, originally, the section operated, as you will see, by imposing a requirement. That's where it was in 1944. Imposing a requirement that this unnatural crime was only committed when the act was accompanied by the use of force or lack of consent. And one can understand easily that sexual conduct using force or without appropriate consent, that could be criminalised. What then happened was that element of consent was removed from the statute, was removed from the law, and that then turned it into simply a known same-sex offence. So just let me pause on that for a moment, because that difference is very, very striking. The idea that there should be a prohibition on the use of force, a prohibition on forcing people without consent to engage in sexual conduct, that I think we would all find a legitimate exercise of legislative power. Precise terms of it may matter. That's some details, important details that we can debate. But by just striking out the words relating to lack of force, lack of consent, it turns it straightforwardly into a criminalisation of same-sex sexual conduct. Okay, so how's the case being brought? The case is being brought in Belize by Caleb Orozco and by UNIBAM. And Caleb is an officer of UNIBAM, which is an organisation dedicated to the promotion of rights including same-sex relationships. The defendant is the Attorney General of Belize, only because the Attorney General is the usual party for cases which are brought against the government. Some of you may know, I was the Attorney General for the United Kingdom at one stage, and I was constantly being sued in cases about which I knew absolutely nothing. Sometimes I did, sometimes I didn't. From one point of view, I was the most litigious man in the country for a period of time. So the Attorney General of Belize may also be pretty litigated against. In fact, it appeared to be the Solicitor General of Belize who'd been running this particular defence rather than the Attorney General. But the case itself, so the case is a Belize case brought by a Belize individual and a Belize organisation against the Belize government. But it's attracted interest, and it's attracted interest from interveners. And there are two categories of interveners. You've heard about three of them: the Human Dignity Trust, the Commonwealth Lawyers Association, the International Commission of Jurists, for whom I'm privileged to act. We're instructed by them to intervene, to support the case which Caleb Orozco and UNIBAM are bringing. It's not our case, it's their case, and that's an important point to underline, because there have been some suggestions in Belize that this is a case which is being imposed on Belize by these terrible overseas foreign people. That's not true at all. It's a Belize case, and we've come in to support them in the belief that they deserve to be supported. I have to say, just before anyone runs away with any other, we're doing this on a pro bono basis, so we will not be paid for our work, and we're very happy to do that because we believe that this is an important case. On the other side, I'm sorry in a sense to see that the churches have combined together to produce a pretty strong opposition to this case. So the Roman Catholic Church, the Church of England and the Evangelical Association of Churches have all intervened in the case to support the view of the government. And I think it's unfortunate because the stand that the Church internationally has taken on these issues is not the same as the stand that the Belizean Alliance are taking. And that's why I underline that this is not about same-sex marriage, it's not about civil partnerships, it's not about adoption, it's not about any of the other rights that people do from time to time say should be accorded to same-sex couples. It's about making it a criminal offence, sending people to prison for doing no more than having a consensual, loving relationship which happens to be with someone of the same sex. There's been assistance on the case. There was research done by the University of the West Indies and the United Belize Advocacy Movement, which is what UNIBAM stands for, have supported the case. Let me just say a little bit more about the opposition to the case on the basis of the churches, because on the 22nd of July 2011, one of the Belize newspapers that many of you may know well, Mandala, reported a joint statement that was issued by the Belize Council of Churches that denounced the suit, Caleb and UNIBAM's suit, as being, and I quote, heavily influenced by foreign interests who seek to impose a worldwide view that directly contradicts the supremacy of God. That's not our view of the case at all, and we very much hope that will not be the view that the Belize Court takes of it. And as I say, I think it's unfortunate that that's the way the case is being presented, because it's ratcheting up ideas about the case. So we just underline, case brought by Belizeans. It's about the Belize Criminal Code, the Constitution of Belize. It's not driven by any foreign entity. It's being supported by these organisations. Nobody is seeking to undermine the national sovereignty and way of life of Belize. That's why, in a sense, I wish that Godfrey hadn't gone back to deal with the election, because I would have preferred there to be a Belize voice here. And Godfrey, many of you may know Godfrey, I don't know, he's a great guy, former Attorney General of Belize, man of principle and dedication, and he would have been able to say that with even more force than I'm trying to do at the moment. But there is a more universal issue in relation to this case, because we believe, and that's why we're supporting this case, that the criminalisation of gay sexual identity is a violation of international human rights law. It does therefore legitimately attract the interest of the international community. And that's what the three organisations that I've got the honour to represent does. They're reflecting the concerns of the international community, particularly from a legal and lawyer standpoint. And we hope that the court in Belize will take the view that Belize is also a sovereign, it is undoubtedly a sovereign nation, but it's also a member of the international community and has every reason to want to aspire to and to share the same values that the international community has. So, why do we say that there should not be this criminal offence? Just sit down and find some water. Excuse me. Well, here is the most, what we think is the most basic statement of position about this, that criminalising consensual same-sex conduct relegates people to an inferior status. It degrades their dignity by declaring their intimate feelings are, and that's the word, remember, in the section, unnatural and illegal. And this breaches, we think, one of the most fundamental human rights, which is the right to dignity. I happen to have been the United Kingdom representative on the European Convention of Fundamental Rights, the European Charter, European Union Charter of Fundamental Rights, which was promulgated by the European Union a few years ago. I was deputed as the representative, and the president of the convention was a man who'd been the president of the German Constitutional Court, been president of Germany, a man called Roman Herzog, a very fine man, a very fine mind, and his position was human dignity was the start for human rights. It's from what everything else flowed from. And I think when one thinks about it, yes, we think in terms of freedom of speech and freedom of religion and freedom of association, but ultimately they can all be traced back to human dignity. And that's why we think that is so important. That's what we are as human beings. We have the right to dignity, we have the right to be respected by our fellow man. And that's what this legislation really hits at. What else is wrong with this section? Well, we have a variety of legal arguments which we will advance, where we will be saying that this is contrary to the Constitution of Belize, because Belize has a constitution which contains, if you will, a Bill of Rights. It has a section of fundamental freedoms, fundamental rights, which are intended to accord to every citizen of Belize these basic human rights, these basic civil liberties. But there are three things, for example, we say this is discriminatory because it creates a situation where different conditions are applied to people unreasonably. It's an invasion of privacy. I'm going to say something more about that in a moment. And it creates inequality. We will also be bringing, and this is one of the reasons why we hope that our intervention will assist the Court of Belize, we'll be trying to bring a bit of an international perspective, not saying, oops, this is an outside view, you've got to accept it, but saying, look, this is interesting to see the way that different countries, not just Commonwealth countries, but countries in Africa, countries in India, as well as the European and the Western countries, how they have dealt with this issue. And you will find it helpful because they analyse it often in terms of human rights, European Convention, and other human rights treaties. But if you look, as we'll say in a moment, if you look at the body, the growing body of human rights law, the growing body of precedents in relation to this, that there is a clear direction, which is to strike down, to get rid of laws which criminalise same-sex sexual conduct. So what does the Belize Constitution provide? It starts by this very, very important recognition set out there, the equal and inalienable rights with which all members of the human family are endowed. And the Belize Constitution is a fine document in terms of its recognition of these equal and inalienable rights. Some people might say it's great, the British Empire was very good at putting on other countries statements, good justiciable statements of human rights, when we didn't think we needed that for ourselves. That all changed. I like to think that they would expect me to say this as a member of the former Labour government, introduction of the Human Rights Act, which for the first time made some of these things justiciable. Be that as it may, it was a good thing when it was put in. And these rights and freedoms which are set out in the Constitution include the right to dignity, to equality, to privacy and to health. Let's examine those a little bit further. Dignity. I've already indicated why we believe that human dignity is the most basic human right from which so many other rights flow. And it's in the very first recital of the Belize Constitution which supports exactly that view. And so it affirms that the nation of Belize shall be founded upon principles which acknowledge the supremacy of God, faith in human rights and fundamental freedoms, the position of the family in a society of free men and free institutions, the dignity of the human person, and equal and inalienable rights with which all members of the human family are endowed by their Creator. Puts human dignity right in there with those very, very key and core rights. And we will be saying, this isn't just words. These are not things just to be paid lip service to. It really means something. One has to examine whether the provisions of the criminal law are actually according dignity as required by the Constitution itself to all people within Belize. So there we are, as I've been saying, the significance of human dignity is in how it founds and underlies so many other human rights. It's used to explain why human beings have rights to begin with. It's used to explain why each and every one of us is worthy of respect. And that is a key element in dignity. And that is why subjecting people, we say, to not just different treatment in terms of rights to marriage or anything of that sort, but actually saying, you are subject to go to prison for an adult consensual relationship. I also mentioned already the right to privacy, and that's an important right to recognised increasingly in many different countries, recognised in the European Convention of Human Rights under Article 8, and it's recognised again in the Belize Constitution. There are two relevant provisions, Section 3C and Section 14. So Section 3 provides that every person in Belize is entitled to the fundamental right to protection for his family life, his personal privacy, the privacy of his home and other property, and recognition of his human dignity. There's dignity again. It's also provided in Section 14 of the Constitution that a person shan't be subjected to arbitrary or unlawful interference with his privacy, family, home or correspondence, nor to unlawful acts on his honour and reputation. And there's this important principle of respect again, that the private and family life, the home and the personal correspondence of every person should be respected. So why does that matter in this context? Well, the present network of human rights instruments recognise the significance of privacy in a very real sense. We've got decisions of the Human Rights Committee, which interprets one of the main United Nations conventions, the ICCPR, the International Convention. There's the European Court of Human Rights, the Strasbourg Court, which applies the European Convention, which has dealt on quite a number of occasions with the right to privacy under Article 8 of the European Convention. There's the Inter-American Commission on Human Rights, which interprets the American Charter, and national courts, because many national laws now contain a right to privacy. Those, we will say, all make clear that sexual activity between consensual and consenting adults in private is protected by the right to privacy. Why should other people have a right to be involved in what two adults consenting together do in private? And to say that what they do, what happens in the bedroom between them, should be regulated by the state, is an invasion of their privacy. You have to, if you're going to respect the right to privacy, you have to respect that people are entitled to, as we say here, a realm of space reserved for their individual decision-making and their individual activity. And the state really needs to have some very good cause to interfere in that. Involve force, involve children, involve coercion, maybe involve drugs, which affect people's freedom to choose. Maybe the state then does, and in some cases plainly does, have a right to interfere. But two adults consenting, where does the state's right to interfere in that come? Personal choice, personal autonomy is a key part of the right to privacy. One of the US courts, if we move to the next slides, has said this, as you can see, it's hard to imagine any activity that adults would consider more fundamental, more private, thus more deserving of protection from governmental interference than non-commercial, consensual adult sexual activity. And to see all the debate that's taking place about phone hacking, about interference by newspapers. What's behind it? Behind it, there is a real concern by some people. What business is it for people to invade the privacy of the bedroom? What people are doing behind their own closed doors? And that's a reflection of the same concern that people are entitled to privacy, and certainly the state ought not to interfere to regulate that, and to regulate that with the clang of the prison door. that's an example of just one of the cases that we will be citing to the Belize Court. Let me turn then to equality. The right to equality is one of the most basic rights. It's recognised in just about every major international and regional human rights instrument. And there are a number of cases of the United Nations treaty bodies, the European Court of Human Rights, the Inter-American Human Rights Commission, and also national courts, which have looked at the right to equality in the context of treatment relating to sexual orientation. We have legislation here now in that respect, but they've all found that differences in treatment that are based on sexual orientation, they're arbitrary, they're in breach of non-discrimination principles, and they're in breach of the principle of equality. And we will be urging on the Belize Court to single out that activity for criminal treatment is another example of a breach of those principles of equality and non-discrimination. You can see, again from the next slide, the very basic but straightforward proposition that we will be making. Anyone, all of you, many of you here will have had to consider the concept of equality. Ultimately, it involves the question of whether difference in treatment, differentiation, difference in treatment is justified. That means you've got to find criteria which are reasonable and objective in order to say this conduct must be treated this way, whereas other conduct of apparently similar nature is treated in a different way. And we cannot see, we will invite the court to look to say why should consensual adult sexual activity be treated in this way? What is it that's justifiable, that's reasonable, that's objective to say that it should be treated by threatening people and indeed, if it comes to it, imposing a prison sentence. And we will be referring to, again, case law from many courts. Here's a Texan decision. Texas, thank you very much indeed, not the most enlightened state in the world, many of us might think. But they've held that laws which criminalise sodomy have no rational relationship to a legitimate state purpose. And there's a very important principle which is to be identified and which we will want the Belize Court to recognise, which is moral disapproval is not the same as a legitimate reason to criminalise activity. By saying that this should not be a criminal offence does not imply any particular moral approval. People can continue to take the view that they don't like same-sex relationships. As I've said at the outset, this is not a question of what other rights may be accorded to same-sex relationships, but this is fundamental, that it cannot be a justification for criminal sanctions. So let's look for a moment then at who is going to decide this. Under the Constitution of Belize, the courts are the guardians of the fundamental rights and freedoms. Section 2 of the Constitution says that any laws which are inconsistent with the Constitution should be struck down. And it is the duty of the court. The court has a power in Section 20 of the Constitution to entertain petitions from individuals and from others who are affected by legislation and to strike down the Constitution. It is a power which the courts exercise in a different context. I've been involved, indeed with Jessica and Vicky, who are with me today, in asking the courts to strike down other legislation, not in this field, but on the grounds that it is unconstitutional. And we were arguing only a couple of months ago in the Court of Appeal the legitimacy of an act. So that this is a real, it's a real power that the courts exercise. They're cautious about it. They're conservative about it. I don't blame them for that. It's a power which is very important and therefore to be exercised with care. But if they find there is a law which contravenes the Constitution, then it is their duty, we will say, to strike it down. And that is an important duty. It's what stands at the end of the day between the people of Belize and a lawless or tyrannical society. So it's critically important. Courts are are part of government, in the sense, not part of the government, but part of the government of the country. They are the weakest part in one sense. They don't have armed forces, they don't have lots of money behind them, they can't pass laws or send the police out. But when it comes to the protection of our freedoms, we have to look to the courts to be the ultimate guardians. One classic area where the constitutionality of law has arisen is in relation to the death penalty. There's been a big, this is not the evening to discuss the way that issues in relation to the death penalty have developed in the Caribbean. It's quite a topic which raises a lot of controversy. But here's one decision, which happens to be a decision by the Privy Council, which at the time was the final Court of Appeal for Belize. That's now changed with the creation of the Caribbean Court of Justice, which will now hear new appeals from the Court of Appeal for Belize. But in that case, the Privy Council, I believe this is Lord Bingham, one of our great judges speaking, said this, that the court hasn't got a license to read its own predilections, its own moral values into the Constitution, but it's required to consider the substance of the fundamental right at issue and ensure contemporary protection of that right in the light of evolving standards of decency that mark the progress of a maturing society. In carrying out its task of constitutional interpretation, the court is not concerned to evaluate and give effect to public opinion. Now that's quite a complicated statement, but it's one that one sees reflected in other areas of human rights law. The European Convention, for example, has been described by the European Court of Human Rights as a living document. It changes with the evolution of society, but not, as Lord Bingham said, simply to give effect to public opinion. Sometimes it may actually move ahead of public opinion. Sometimes it may seem to lag behind. Certainly it's not a question of the court identifying what its own moral views on some subject are, though it's impossible for judges not to have some recognition of their own views. They're only human after all. But it does underline that there should be an objective assessment, but not one that stands still. So a law that was enacted in 1944, and there may have been very good reasons in 1944 to have enacted such a law, that may have been the state of society at the time, doesn't mean that it stays like that forever. Shouldn't, and it should be judged in the light of as Lord Bingham said, evolving standards of decency and the progress of a maturing society. And I hope we will be persuading the court in Belize that that's exactly the approach that they should be adopting and recognising the way that the world has moved since 1944, including that the British have gone. What's the timetable for this? We had actually hoped that this case was going to be heard last year. At one stage it was scheduled to be heard. The tickets had been bought, the suitcases packed, the legal textbooks wrapped up, ready to go, the skeleton argument prepared. We're actually getting a bit concerned. I'm getting concerned as to what's going on. The churches then came in to make their application. They made it quite late. You know, one wouldn't want to say, oh, you're too late, you're not allowed to say anything. That we believe in everyone having an opportunity to make their case. I'm beginning to get more and more concerned as to whether there's some let's play in the long grass. And the most recent application that took place did not set a date, which I hoped it would. I'm still quietly confident that we will get this case heard in 2012, because obviously there's every chance that in any event, where the case is heard, will be heard at first instance, that will not be the last place. The case can go to the Court of Appeal and on to the Caribbean Court of Justice. And just to say a word about the court structure in Belize, for those who aren't familiar with it, Belize has a system of High Court judges who are permanent judges in Belize. It has a sort of part-time Court of Appeal, by which I mean that the Court of Appeal sits 3 times a year for a period of 3 weeks, very occasionally for special sessions as well. And the judges are not necessarily Belizean. One of them happens to be at the moment, but there are a panel, I think, of 4 at the moment, maybe 5 judges who are used to the Court of Appeal who come from different jurisdictions. Some of them sit on other courts, some of them only sit on this court and then have another activity. One of them, quite a new appointee, for example, continues practice as a rather distinguished barrister and human rights lawyer. So there's a strong Belize High Court. There is then a court which comes from outside to a large extent in the Court of Appeal, and then ultimately cases will go to the Caribbean Court of Justice, set up as an alternative to the Privy Council for those Caribbean countries who want it, which sits in Trinidad, which hasn't had much of an opportunity yet to demonstrate what it's going to do, but it's started. So I expect we will end up there at some stage. What are the global trends? We'll be talking to the court about that. The majority of the world's countries, same-sex relationships are not criminalised. And that's either because they never were criminalised, or, and there's quite a number of these, that either the legislature or the courts have recognised that the criminalisation of adult same-sex relationships violates international and national human rights standards. So we, I think, believe that there's still, however, a significant number of countries that do criminalise homosexuality. We believe there are 84 countries, of whom 42, which troubles me, 42 are Commonwealth countries. And that's a big statistic, and it may have a lot to do with the history as to how these statutes came into existence. But if you exclude 2 courts, Zimbabwe and Botswana, every superior, every constitutional, every supranational court that has been asked to consider the issue of the criminalisation of private consensual same-sex relationships has held that they contravene fundamental rights and freedoms. A number of times the issue's been raised. Every time the superior courts and the supranational courts, the ECHR, the Inter-American Commission on Human Rights, with the exception of Zimbabwe and Botswana, they've held these are unlawful and have struck them down. So, some examples. I referred already to Texas, the US Supreme Court in Lawrence, Texas. That was a very important decision because that overturned a previous decision of the US Supreme Court in Bowers and Hardwood. They did it on the basis that intimate consensual same-sex conduct was protected by the substantive due process requirement of the 14th Amendment to the Bill of Rights. South Africa, they struck down statutory provisions prohibiting sodomy on the grounds that they were unconstitutional in the National Coalition for Gay and Lesbian Equality and the Minister of Justice. The South African Constitutional Court held it violated the right to equality, to privacy, to dignity, and also unfairly discriminated. That's an important decision which we will be relying on. Outside the judicial arena, in December 2008, 66 states signed a statement presented to the UN General Assembly affirming the principle that international human rights law protects against violations based on sexual orientation and gender identity. And in March 2011, 85 states signed a statement which presented to the UN Human Rights Committee that called on states to end criminal sanctions based on sexual orientation. So there's a movement that is taking place to change those cases where these laws still exist. The OAS has repeatedly condemned acts of violence and human rights violations committed against persons because of their sexual orientation. Let me say a word about this because it's one of the things that's relied upon in this case, in Caleb Orozco's petition, because he says, and it's entirely understood, he has been subjected, as so many gay men have been throughout the world, to threats of violence or actual violence based on the fact of their identity. And of course, here is the state supporting them. saying, you're right, these are criminals, these are people who should go to prison. And even if the prison sanction isn't that often exercised, it's sending a message that separates these people and legitimises conduct which is demeaning, conduct which is damaging, and conduct which is actually physically violent against such people. So it's absolutely right to pick on violence and acts of violence as one of the reasons why this should not be permitted. And the UN Secretary General, the High Commissioner for Human Rights, heads of various UN agencies have all spoken out, calling for the worldwide decriminalisation of homosexuality. Obviously, we hope that the Belize Court will take the same view, not because they're told to from outside, but because it's right. And that's why we'll be relying upon this material. Ban Ki-moon, the new UN Secretary General, let me see what he says. He says we must reject persecution of people because of their sexual orientation or gender identity who may be arrested, detained or executed. Sadly, that still happens in some parts of the world, for being lesbian, gay, bisexual or transgender. They may not have popular or political support, but they deserve our support in safeguarding their fundamental human rights. I understand that sexual orientation and gender identity raise sensitive cultural issues, but cultural practice can't justify any violation of human rights. Moral disapproval, cultural differences are not a justification for treating people in this way. Now, let me just pick up something else, because as we've noted, the Belize Churches Alliance are coming in order to say that this is outrageous and this is against, well, I said, against the will of God. But we have statements made by the highest authorities within the churches, global churches, taking a different view. Here is the Holy See in December 2009, continuing to oppose all growing violations of human rights against homosexual persons, and that the Holy See opposes all forms of violence and unjust discrimination against homosexual persons, including discriminatory penal legislation which undermines the inherent dignity of the human person. We agree, that statement is right. That statement is right, and it can come from an authority as Catholic in both senses of the word, and as that, and then it should be something that's acceptable to the courts of Belize and other countries. Let's just move on to some sort of high politics. President Obama, he's taking, and one isn't surprised by that at all, but active steps to persuade countries which at the moment criminalise homosexual conduct, and David Cameron has pledged to withhold UK aid from governments that don't adhere to proper human rights, e.g. Malawi had 19 million budget support suspended following concerns about its attitude to gay rights. There was a recent case about Uganda too, the British government having acted in the right way by recognising the wrongs. I want to conclude this, maybe an opportunity for comment, please, and questions, really by referring to what Michael Kirby, Justice Michael Kirby, of the High Court of Australia, he was the High Court of Australia, an extraordinarily fine jurist, also open about his own sexuality, but he has bravely but very clearly enunciated why this is all wrong. And he identified 4 wrongs, and I think this is a good place to really to summarise what we hope to say. It's wrong in legal principle to criminalise consensual adult same-sex activity. It exceeds the proper ambit, the proper function of the criminal law in a modern society. It makes moral values the same as legal values, the same as legal conduct, and the same as criminal responsibility. Secondly, it's wrong because it oppresses a minority in the community and targets them for an attribute of their nature that they don't choose and can't change. So, non-discrimination, equality, dignity, those elements we've been talking about. Thirdly, it's wrong because it flies in the face of modern scientific knowledge about the incidence and variety of human sexuality. In our case in Belize, there's ongoing debate about the extent to which expert evidence is going to be admitted by the court, which will touch on this aspect but also other aspects. For example, which is the fourth one, and we want to deal with this, it puts citizens into a position where they are stigmatised and where it becomes difficult, if not impossible, to reach them with vital messages about health and safe attitudes to sex. And there's a lot of research which demonstrates that if you criminalise same-sex conduct, you make it much more difficult for people to adopt attitudes which are safe in relation to their human relations, and which therefore is very damaging to the fight against HIV and AIDS. And that's one of the areas of expert evidence that, as I say, we want the Belize Courts to hear, but it's controversial at the moment. I started by underlining that this was a Belize case brought by Belize people in a Belize court against the Belize government. But you've also heard the statistic that I identified about the number of countries which still criminalise same-sex sexual conduct and how many of them are in the Commonwealth. And there are a large number of them in the Caribbean, and there are reasons why that may be so. But although it is a Belize case, it has the opportunity to set an important precedent for the rest of the Caribbean and for the rest of the Commonwealth. And we hope that, and the organisations who we represent hope, that if the Belize court can be persuaded by CALEB and UNIBAM, and we hope with our support, that they ought to say that under their constitutions it's no longer acceptable for this to be a criminal offence, that other Commonwealth courts, or maybe other Commonwealth legislatures, will follow, recognising the justice of that position. And ultimately, that would be a tremendous outcome of the case. Let me conclude. What's going to happen? Well, I drafted this really quite carefully and advisedly. In our view, ultimately, the Court of Belize ought to declare that Section 53 is unconstitutional. You've got the point. I very much hope we will be able to report to you at some stage that not only ought they to, but they have. But we have an issue in front of us, not because I had any doubts about the legal merits of our position, but because it is a big challenge for the courts of Belize. It is a big issue. We recognise that. The intervention of the churches makes that all the more evident. But we very much hope that they will see their duty under the Constitution, and that the right thing to do to right an injustice is to declare Section 53 unconstitutional. Godfrey would have done it better, but thank you.
Thank you very much indeed for that very clear and concise overview of the Belize case in its international context. We have time to take some questions. I know there's people in the room interested in the legal dimensions, in the Commonwealth dimensions. I know there's people in the room who were involved in attempting to reform the Belizean Constitution. So I'll open it up to the floor, and yes, Claire, and yeah.
Hello, good evening. My name is Paul Ragnitz, and I'm a student of the school. And I'm following this case in particular because I found it fascinating. It's a case of study. Personally, I have experience as an activist in Spanish and US America. And this case is completely different because it has implications in the Commonwealth and it's another legal framework.
Yes.
So I have some points I would like to raise, and some thoughts that I would like you to consider. First, the transnational level and the impact of the HIV pandemic. It has a big it's a big argument that we're bringing in this case. And secondly, in 2009, the New Delhi High Court decriminalized sodomy. And within the Union of India, there were different bases and positions within the respondents. Let's say the General Attorney represented the Home Affairs have a position against ruling that is unconstitutional to criminalize sodomy, and then the Ministry of Health had a position that in order to fight HIV we needed to address this issue as a public health matter. So this brings me to a third or a reflection that I'm thinking, to what extent this is a case about human rights, let's say the right to privacy, equality, and human dignity, or a public health issue as to the efficiency of the use of the funding and implementation of policies that are put into development strategies in the third world countries. International aid. Thank you.
A lot in there. So
No, a lot in there, but really good points. And the answer to your fundamental question, is it about human rights, is it about public health, is both. Because the right to health is itself a human right. And you're absolutely right to draw attention to the Indian case, the Mass Foundation case, because that did pick up in a very effective way on the public health issues, and we will want to present that to the court too. And those are, as you say, essentially that if you want to create, to have a population which has a health at a good standard, then you have to deal with HIV, we have to deal with AIDS, and you can't do that if you frighten people off admitting their sexuality or simply excluded from society so you can't reach out to them. We will want to make that point. But I don't want to restrict it to that. Not because I don't think that's important, but because I think there is still something that is higher than that as well, which is, I come back to it again, the right to human dignity. And I think we have to, we will use this as a supporting argument. We'll make the point about the right to health. We say that's a right protected under the Constitution, but we want to underline the equality, the non-discrimination, and above all, the right to human dignity. So thank you very much indeed for your question. I mean, and thank you for your interest in the case.
Dylan, and perhaps you can introduce yourselves before you ask the question.
Yes, I'm Dylan Vernon, a Belizean who is now a student here at the university. One of the things I did in my former career was to chair the Political Reform Commission, which was looking at basically revising the Belize Constitution. And I was part of a group of commissioners who had attempted to recommend that we have a clause in the Constitution's preamble that would basically say that you cannot discriminate based upon sexual orientation. It will not surprise you that the churches who were represented in the commission made a huge fuss about it, and eventually got the political parties who were also there to back off, and it was buried. But the point is, the churches are extremely powerful in Belize. There's a church-state system. The politicians treat the churches as sacred cows. Most of their voters have some affiliation with the church. So both political parties are playing this very carefully. The government is hiding behind the fact that it has no other alternative but to defend the law, which is bollocks. But we also find that there is now, I don't know if you know, and you most likely do, that the church is using the very same clause that you put up a while ago about the supremacy of God as its basis for constitutional basis for supporting the continuation of this law. And finally, I'm not sure if you're aware that, I'm sure you are though, the Monday there was the case that launched in Belize, where there was preliminary discussions, and basically what happened was that, and you're right, the church is basically trying to push this thing as long as it can. It challenged the affidavits that have been presented, it challenged expert witnesses, it tried to say that UNIBAM cannot be
Yes.
involved because it was not a person.
Yes.
And so there are all these arguments. So even before the case has begun, there's usual. I don't know what phase you caused this, but it seems that this will be also drawn out because the judge hasn't set a date for giving
Exactly.
verdict on whether I think the churches are asking for the case to be thrown out even before it goes.
They're asking for UNIBAM to be denied the ability to appear on the grounds that it is not affected, it's not a protected person under the Constitution because it's really an NGO, a non-governmental organisation. That can't affect, in my view, the standing of the other claimants, Caleb, to bring a case. So I think ultimately it doesn't make any difference. But I think what's happening, I think you're absolutely right, I think what's happening is that they're using all these arguments, affidavits, expert evidence, standing organisations as a way of drawing out the whole of this process so that it doesn't get decided. I think for the moment, the government is at least happy for it not to be dealt with before the election.
Yes.
After the election, they may be less concerned about it, though, as you say, they're happy to take this position. And as to the standing of the church in Belize and indeed in other Caribbean countries, I'm under no illusions about it. And I don't, for one moment, object to the strong adherence to the church that many people have. But you only have to walk down the street to see how many places of worship there are. Some people would say it would be better if we had more in this country, but it shouldn't stop the court, and that's what we're going to have to persuade the court, taking the right attitude to human dignity, to equality, to non-discrimination, and indeed, as we said, to important public health issues. So,
One short follow-up question on has the government presented any arguments itself? Because what I gather from just looking at how that case went is that the government is basically saying, well, whatever the church says, we agree with. And it's not even presenting or defending as such the case on its own. That seems to be the strategy
so far. They've done very little. I mean, the previous Solicitor General put in an affidavit which was this is the law, we should support it, and so forth. I'm not sure the new Solicitor General has said anything yet, Cheryl Cruz, I'm not sure. But I think with the government, of course the government's going to play it that way. And we will say they cannot sit on the fence in that way, they cannot avoid their responsibilities, because I'm a firm believer in this, that although I've said that the courts are the ultimate guardians of fundamental rights, the government has a responsibility, in every country has a responsibility to protect the human rights of every member of that community, and they should look after them too. And if they push same-sex relationships, if they push gay people aside, then they are failing in their duties too. But whether they respond to that argument is a different matter.
Yes, please.
My name is Mark Searle. I'm a PhD student at the LSE. Two questions. First question is, how did the case come about? Why has it come about at this particular time? You mentioned that the case is a Belizean case. I seem to recall from a human rights friend of mine hearing that there had been an idea to launch similar cases in Jamaica and in Trinidad. And so I thought that there had been, or there must have been, some sort of coordinated action amongst members of the legal community or the NGO community, and that this may also involve people beyond the region. So I'm just curious as to whether this case has arisen entirely in a vacuum in Belize, or whether it's part of some sort of broader effort.
And your second question?
Well, this is linked to the first question,
Sure.
actually. Has this in Belize ever gone down the political route? Has there ever been any effort to deal with this via the legislature or legal reform? The second question is, well, as I'm sure you are aware, other jurisdictions in the Caribbean have savings clauses that effectively prevent certain bits of legislation
Yes.
from being challenged,
Yes.
legislation that was there before the Constitution
Pre-existing
came into
legislation,
effect.
yes.
I assume that's not the case in Belize. Otherwise, this challenge could not be raised. I just wanted to confirm if that's true.
Yeah.
And if so, how do you see this case being precedential to those other Commonwealth Caribbean jurisdictions, particularly on a sensitive issue like this, and particularly where it goes down the judicial route rather than the political route?
Let me just pick up on that first of all, political, judicial, because these two things are not distinct. They're not completely distinct. Speaking of someone who's straddled both sides, and he still do, because I'm still a member of the British House of Lords and so a member of the British Parliament. One can influence the other in a proper way. If, for example, there were a reasoned decision from a court which had obviously looked at this carefully, which came from a similar culture and tradition, so it couldn't just be ignored on the basis that, that's the United States, that's Britain, whatever it may be. Then I can see that even in a place where there isn't the possibility of a direct constitutional challenge, the legislature might say, that's enough, particular legislature which would actually like to move on, but needs a bit of protection, as it were, a bit of cover to do so. I can see them taking a decision like that and saying, that's really the line that we ought to take, even if our courts couldn't actually quite impose that on us because of the saving clause in our constitution. So I think the two things will go together, and we will see. I mean, this is because of the number of countries who are affected by this. This is the long process. So far as how this started, as I was also showing before, there is quite a movement in this field which is coming from different areas. So we talked about Obama and Cameron and the Holy See and the United Nations and all of that. I think what's been happening is that there have been a number of concurrent movements that have been going. I know that UNIBAM strongly takes the view that it and Caleb wanted to bring this case in Belize, and it's only subsequently that the institutions whom I represent, for example, then came into support. They having taken the view, it's quite right, they having taken the view, as it were, that it was a good time, it's right for there to be legal challenges to laws relating to criminalising same-sex sexual activity in different places. But the Belize case started because it was a Belize case, because there was a Belize imperative to do so, and we've been able to come in perhaps to support them, we hope helpfully, because of this other groundswell.
And sorry, had there been any political discussion around it before that?
We're probably going to get a better answer from that from our colleague before, who was actually on the Political Reform Committee on the Constitution, who was telling me that there was an attempt to get a change to the Constitution to deal with to impose a prohibition on discrimination on grounds of sexual orientation. So you can see that this has been around as a political issue.
Any further questions? Yes, Leonie.
I'm Leonie Jordan, and it's quite some time since I did constitutional law, but I understand that you're part of a team that is acting pro bono.
Yeah.
The Church Alliance, is there any indication of the sources of their funding? And are they instructing local Belizean barristers to represent them before the court, or are they bringing, likewise, a team of international jurists to represent the court?
I know who their lead lawyer is, because I know him very well, and others here may do. Eamon Courtney, senior counsel, a very, very powerful and distinguished actor. Former foreign minister, I think, wasn't he? Was he Attorney General as well, I think? Yes. Yeah. So I know he's represented. Whether Eamon thinks he needs any support is another matter. I suspect Eamon he probably doesn't. So, and as for the source of funds, I have no idea.
Yes, at the back.
Are there any lessons to be learned from Zimbabwe and Botswana? Sorry, I'm Andy from Champalia.
No, I wasn't smiling for that reason. I thought there were a lot of lessons to be learned. You weren't putting it quite as broadly as that. I mean, obviously, what we will do is we will present this in a fair way, and of course, when we come to tell the court about the experiences in other parts of the world, we want to tell them about those areas where the experiences have not been, consistent with the general thrust, and we will then look at those cases and say why we think they're wrong or why they're distinguished, whatever it may be. So there we are. I'm not spent some time in Zimbabwe, and I'm not sure I'll put it forward on any basis as necessarily a great precedent for anyone else.
I am Belize Advocacy and I'm a student here. And you mentioned that the church internationally has actually quite a different position from the church in Belize. And I wonder, does it have any involvement in pressuring maybe the Belize church to adopt a different position, or not at all?
Well,
No.
I don't think it would be for me in any event to try to encourage that. I mean, I think what we would like to do is just to demonstrate to the court, which may not appreciate it, that this is not, whatever the advocates for the council church are saying, this is not a universal view held by church leaders. I think that's important. But as we know in religion, there are more than one view about everything.
Very quickly, yeah.
Just quickly, and it's a statement that you have of the ought part. I mean, you clearly have some reason to put the ought there. The church's legal position that they're going to present. Is there anything about it that gives you pause?
No, there isn't. There isn't. But I recognise the realities of the situation, the realpolitik which exists, and that to ask any court to strike down a law, I can see circumstances in which courts in many parts of the world would say, when faced with this, we think it's not for us to say, we think there's a strong case, we hope the legislature will consider it carefully and act. That sort of argument, so as to push it off. I don't think that would be right, because I think the Belize Constitution does have this clear obligation on the courts to uphold fundamental rights, and I believe that this provision absolutely strikes at those fundamental rights. That's why I believe it ought to do that, but I'm a cautious guy.
So a quick last question from Cheryl.
Hi, Cheryl, I'm a student here as well. I just have a question, a quick one. So you said that Caleb mentions the violence, and you spoke to the violence, and how that promotes violence against gay people. Are there other examples of other people coming forward as part of the case to discuss the violence that has either, that they've experienced, or other concrete examples of how this affects them day to day?
Yes, I mean, there are examples that are referred to in the evidence, but I mean, I think anybody who studied this, even for half an hour, knows this is what happens in many, many parts of the world. There's no getting away from it. It's a reality, and so long as the state is saying, these are bad people, these are criminal people, these are people who should be locked up, it's going to encourage that.
I just wanted to ask if you saw any hope in the recent statements of Portia Simpson in Jamaica, and will the international team involved in Belize Courts have the energy to go on look elsewhere, so after Belize, Jamaica, or?
Our energy is inexhaustible.
Well, I want to thank you again for coming to us after a very busy day at work, for coming to us at such short notice, and for giving us such a clear outline of the case. And I'm sure I speak for all of us in the room to say we wish you well in this endeavour. So thank you very much indeed.
Thank you very much.